This is the Landlord Advocates, where we help landlords become better landlords. I'm your host, Matthew Lyman. Welcome. Landlords, New York State has done it again. They instituted a new rule that landlords must follow, and if you do not follow this rule, your case can be dismissed in court. Your eviction case can be dismissed in court. But before we tell you what the new rule is, we want to talk about the document that it pertains to. This is a document that must be inserted in the summary proceeding documents that you have served upon your tenant. Those are the documents that you go to the court, that they put a docket number on, a date and time, and your process server shows them onto your tenant. This one document has to be inserted. It's a document created by Administrative Judge, Chief Judge Lawrence K. Marks of New York State. It has to have been inserted for the last few weeks, but this new rule now pertains to that document. But we want to let you know what it is first. We want to read you this document so you know what it means. Notice to respondent tenant. During the coronavirus emergency, you might be entitled by law to special defenses and protections relating to evictions. Please contact your attorney immediately for more information. If you don't have an attorney, please visit and they provide websites. There are 4 variations of this document. 2 are for housing courts inside of New York City. 1 in Spanish, 1 in English. 2 are for eviction courts outside of New York City. 1 in Spanish, 1 in English. We went to the websites that are on these documents. Now, all 4 of these will be in text format in the description below. We would love to be able to send you links in the description below, but until we get 1,000 subscribers to the Landlord Advocates, we cannot do that. This is your cue to subscribe to our channel right now, inform your fellow landlords to subscribe, landlord associations to subscribe, hit the notification bell, hit the like button, and leave comments below so that we can respond more and help you even more later on. We have more videos to come. But when we went to these websites, we visited the one for housing courts outside of New York City. It's a 2-page website, and it provides for web addresses and links to help tenants fight the eviction that you have filed against them in court. There's a sentence above the one for outside of New York City that we want to read to you. The information below is designed to help you find a lawyer, or if you do not have a lawyer, to help you learn about your legal rights and the resources that the court system provides to help you with your case. Resources that the court system provides to you to help you with your case. Well, help means to help fight the eviction that the landlords have put forth to get you out for either destroying the property, not paying the rent, or both. Now, when we went to the one for New York City, it was a 1-page website. You might say to yourself, okay, 1 page, how bad can it really be? It's only 1 page. It's worse. It's worse. It provides for 4 web addresses / links for tenants to go to get help, legal help and otherwise, to fight the eviction that you filed against them. It also provides not 1 phone number, not 2 phone numbers, not 3 phone numbers, but it provides for 15 phone numbers that tenants can call in New York City to get help to fight you, the landlord, to get the tenant out of your property. 4 web addresses and 15 phone numbers. Little overkill if you ask us. Are there phone numbers and web addresses out there provided by the state to help you, the landlord, get free legal advice, free attorneys, to represent you in court and get your tenants out? Of course not. Of course not. So not only are there no resources out there other than Facebook pages for landlords like NY Landlords, Landlords Only, and of course, the landlord advocates that are here to help you. But there are no other organizations out there to help you that the government mandates that they gotta provide you the information so that you can help yourself. But we, as landlords, have to provide this document to the tenants so that they can take that and fight you on it. Now here is where this rule comes into play. According to Judge Lawrence K. Marks, like I said earlier, who is the Chief Administrative Judge of New York State, he has decided that these documents are to be printed on colored paper to enhance its distinctiveness and effectiveness. So not only do you have to give them this document, this loaded gun with bullets in it, you have to actually put it into their hand and put it to your head. Because now it has to be on colored paper to make it effective and distinctive from the other papers that you serve upon them. But there might be a way out here. There might be a way out. He did not say what color the paper had to be on. Can we put it on ivory color paper that is indistinguishable almost from white paper? If you choose to do this, I would bring the wrapper in which you bought the paper in, whether it be Xerox, Boise, Hammermill, whatever the brand might be, to show that this is in fact colored paper. It didn't say it had to be on neon pink, blue, orange, yellow, green, the color of Sharpie highlighters. It didn't say that. It just said colored paper. But here's where you may run into a problem. When the courts turn around and say, from the bench, legislate from the bench, that this is not distinct enough, it just said colored paper. But will the judge dismiss it because it wasn't on bright neon paper? Will the court next? Will Judge Marks next? Will Governor Cuomo next mandate that your process server gather the tenants around a fireplace with hot cocoa and sit in a rocking chair and read these documents to the tenants and make sure they take notes? Is that next? When we talk about effectiveness and distinctiveness, don't you believe that these moratoriums from Rhode Island to California to Texas to Florida, New York, and all around have not been effective? I can tell you from the landlord's perspective, it sure hell has been. Landlords can't get tenants out. And if they can, they may not get a judgment. They may have destruction of property. So these moratoriums, agency orders from the CDC, administrative orders from judges, and judges decided to legislate from the bench, have been quite effective in hurting the needs of landlords, but have surely been effective in advocating for tenants. So now landlords are being put into a new rule that these documents, these 4 documents, whichever you have put to the document to serve on your tenant, now have to be on colored paper. Landlords, we don't know what more is coming down the pike, down the river, but we know it's the Colorado River with all the turbulence and the waves and the rocks that are in the way. It's one hell of a bumpy ride that we're on, and it's not going to end soon. Will the moratoriums be extended come January? Will there be a cancel rent movement that gains strength? Will there be a rent forgiveness movement? There are out there. And we're going to talk about those soon in very soon upcoming videos. But until then, subscribe to our channel, hit the notification bell, hit the like button. That lets YouTube know that you like our videos, share our videos, so that it can help you and other landlords. Until then, stay safe, and remember, we're here with you, and we're here for you. Take care.